Another action-packed day with the broadening out of the issues that we're looking at. Quite a lot of discussion yesterday about ADR and ODR. So this morning we kick off with a panel on those subjects. The area of ADR strikes me as being one which is exploding, not only in terms of volume, but also in terms of range and different types of architectures. The classic style of ADR is simply mediation within a court setting, but there are so many different situations now within which broad ADR techniques of mediation or negotiation or some form of adjudication are appearing in other architectures, in the context of other architectures that are not necessarily courts. So there's a huge range of options to look at. We're going to start this morning by looking at the perhaps more classical context because of the litigation environment in the US. So Linda Molyneux will start off talking about that areas, and then Ornat will go into an extremely interesting sort of groundbreaking area in relation to a manifestation of ODR. And if there's time at the end, I will slot in a few comments about consumer ADR in Europe. So, minimalist introductions. We're very pleased to ask Linda to talk to us about the US. Thank you.
Is this on? Can you hear me? Yes? Is it working? Okay. Okay, good morning, everybody. And again, I'm very, very thankful and pleased to be here. So the topic for this morning is alternative dispute resolution in relation to collective settlements. And when I was asked to talk about this, I thought it's kind of an interesting construct in the American context because we are so focused on the formalism of the class action rule. And yesterday in panel after panel, we kept hearing about the American class action rule, the American class action rule. And I think you can, from listening to this, you can form the opinion that somehow or other we have the class action rule, class certification, and then something happens with the class litigation. There was some discussion of settlement classes. But I think you would have an incorrect appreciation of the way in which complex cases are actually resolved in the United States if you have this monomaniacal focus on the class action rule. And what I want to suggest to you is actually the reality of the way that complex cases are resolved in the United States today is somewhat different and more complex, and actually has migrated to a different model. And that's the model of the multi-district litigation. In shorthand, we call that MDL proceedings. And my colleague Morris Ratner yesterday at the end of his presentation introduced you to this concept of MDLs. When we're talking about use of alternative dispute resolution in resolving settlements in the United States, I'm going to talk to you and walk you through 4 different modalities where resolution of these complex cases has become infused, if you will, with alternative dispute resolution techniques. And the 4 different models or modalities I'm going to talk to you about are class settlements within the context or under the umbrella of MDL proceedings. That's one model. The second model is non-class aggregate settlements under the umbrella of MDL proceedings. Then the third modality that I want to talk to you about is a much more traditional type of ADR auspices, which is this interesting problem of class-wide arbitration. And notwithstanding the fact that yesterday Rhonda Wasserman told you that our Supreme Court has endorsed class action waivers, we still do have class-wide arbitrations. So I did want to talk a little bit about that. And then the fourth modality, which is something that hasn't come up at all in any of the panels yesterday, but is a kind of alternative dispute resolution, is the use in the United States of fund approaches to resolving originally mass disasters, but has now expanded to other kinds of complex disputes. So that's the terrain, that's where I'm going. But I do want to talk a little bit about this MDL model, which, as I said, we're really living in the ascendancy of the MDL model. And so how did this come about? First of all, let me backtrack and reiterate what Morris Ratner said yesterday. We have Rule 23, which is the class action rule. But we also have this statute, and it's called the Multi-District Litigation Act. It's found at 28 U.S.C. 1407, for those who are interested in citations to statutes. And what this statute provides in our federal system, it allows for transfer of all pending cases that share a common facts or legal theories, and it allows for the transfer of all these cases to one federal judicial district to be consolidated. So, for example, if there are asbestos cases filed throughout the federal system, the MDL statute permits all of these cases to be transferred to one federal court under the supervision of one judge. We have something called a judicial panel on multi-district litigation. They convene every few months, and they make a determination as to whether or not to create an MDL for a particular type of litigation. And when all the cases are transferred to the MDL court under the supervision of the MDL judge, the purpose of MDL proceedings is to accomplish coordinated pretrial proceedings. And what that means is basically to conduct discovery into the cases, and also for the judge to handle any pretrial dispositive motions. The MDL statute does not permit trial in the MDL forum. And so the way it's supposed to work is after consolidated pretrial proceedings, the MDL judge is supposed to transfer all of the cases back to their originating courts for disposition. That's the way the statute is set up. The way it works in practice and reality is that cases that go into MDL proceedings very rarely get remanded back. They almost usually, in a very, very high percentage of cases, settle in the MDL auspices, right? So the MDL proceedings has become a very, very important procedural mechanism for aggregating large numbers of individual cases in complex litigation. Now, the MDL statute was enacted in 1968, and this procedure was not used very, very frequently. We really didn't have a lot of MDL proceedings, and I want to give you just very briefly how this burgeoned into the predominant mechanism it is today. And also this dovetails with part of the narrative that you heard from my colleagues yesterday. We also didn't have the mechanism of the settlement class for a very long time. We began to see settlement classes in the 1990s. As a matter of fact, the decade of the 1990s was the great era when settlement classes first emerged, and at the end of that decade, that's when the Supreme Court had to consider the legitimacy of settlement classes in our Amchem decision in 1997 and Ortiz in 1999. And so that gave us this mechanism of settlement classes. But the other part of the narrative is in 1995 and 1996, in our federal system, there were landmark cases in litigation classes that made it very, very difficult to pursue complex mass tort cases in federal court. There was a negative reaction in very important decisions. And as a consequence of that, the plaintiffs' lawyers, because it became so hard to pursue these cases in federal court, threw up their hands and said, well, okay, if we can't bring these cases in federal court, we're going down into the state court systems. And that's what they did. It was, again, an interesting era, and the plaintiffs' lawyers basically abandoned our federal courts and went down into favorable state court forums. If you were on the defense side of the docket during this era, the defense lawyers dubbed these as very colorfully as judicial hellholes because they were terrible, terrible places for defendants. After a decade, between 1995 and 2005, of these complex class actions basically being adjudicated in the state courts, Congress enacted CAFA, the Class Action Fairness Act. And again, my colleague, Rhonda Wasserman, talked to you yesterday about CAFA. CAFA was basically lobbied through Congress by the Corporate Defense Bar because they wanted to get their cases out of these unfavorable state courts. And so beginning in 2005, pretty much the great era of class action litigation in state courts ended, and now everything was being removed up into federal court. So from 2005 forward, for this past decade, most complex class action or most complex collective action has been in the federal system. What's interesting in this same period post-2005 is when we begin to see the dominance and the emergence of MDL proceedings. Pretty much prior to that time, MDLs had been used, but not very robustly. But beginning in 2005, you begin to see a major, major change in the litigation terrain. Nowadays, whenever a complex products case or mass tort case, securities case, any type of complex litigation emerges on the scene, is published in the newspaper, almost immediately there's going to be creation of an MDL. It's the most astonishing change. And so what happens is the judicial panel creates an MDL, and all of these cases are transferred before one MDL judge, right? And so this takes me to the major portion of what I want to say about alternative dispute resolution, right? So we're now again in this great era of the ascendancy of MDL proceedings. What happens when an MDL is created, the judge will basically ask the attorneys to file petitions for which attorneys want to take the lead in the case and be appointed as lead or liaison counsel. The judge will set up various litigation committees under the umbrella of the MDL. And then what will happen is the attorneys in these cases basically will go forward. And what they're supposed to be doing is ongoing discovery. But the MDL umbrella actually serves as a major mechanism for accomplishing settlements. Now, yesterday, Morris Ratner told you that typically one of the things that will happen in these MDL proceedings is eventually at the back end it will generate a standard class action settlement, right? And that's the first model. So you'll have MDL proceedings. The attorneys will get together, they'll negotiate a settlement, and then at the back end, they'll have a deal, and they want to be able to go to the judge, and they want it resolved through class action auspices. And the reason they want it, the deal done under class action auspices is so that they can gain the res judicata binding effect of a class action. And when they do that, the deal has to be approved by our judge under Rule 23E, so there has to be a fairness hearing. So this is one model that currently exists. And an interesting development, again, over the last decade, when we have this pretty standard model of formal use of the class action rule, is the introduction of mediators into this process. And so it's now fairly common when you have a proceeding under MDL auspices and the attorneys are over weeks or months negotiating a deal, for the judge to ask a mediator to join this process, or the parties themselves can request a mediator. And then a mediator will come in during the course of negotiations and do what mediators do, which is basically a version of kind of shuttle diplomacy between the contesting parties and go back and forth and help them to accomplish a deal. Another thing the mediator may do is to help them not only with the substantive terms of the settlement, but will help them to procedurally figure out how they want to craft the settlement so that it will accomplish approval by the judge at the fairness hearing. If a settlement is reached, a class action settlement is reached, and they're going to present that to the judge, one of the interesting things now is that the mediator who has been working with the parties will submit an affidavit. an affidavit as part of the package that goes to the judge during the fairness hearing, and the mediator will be able to describe to the judge, this is what the litigation is about, this is when I came into the litigation, I can assure you that there was arm's length bargaining between the parties, that the terms of the settlement are fair, adequate, and reasonable. And he's saying this as a first-person neutral. I was there to help the parties. And so this affidavit from the mediator is used to educate the judge and to support approval of the settlement. So again, that's been very, very interesting, this use of mediators. This model used to not exist, and now, again, when I have been involved or seen MDL proceedings that are leading to class actions, almost all these cases have mediators in them, and almost routinely you have an affidavit from the mediator. So that's the first model. The second model is a variation on this theme, and this is where cases are transferred under our MDL proceedings, and they go before an MDL judge. But rather than the parties getting together and negotiating with an eye towards having a class resolution at the end, we now have this new invention which is called a non-class aggregative settlement, a non-class aggregative settlement. And if you're wondering what that is, that's a very good question. Basically, it's all the parties getting together and cutting a deal, and they reach an agreement, and that's it. Okay, they've got the terms of their settlement, and they're going to ask that the case be dismissed from the judicial system. The way in which it's markedly different is it's not subject to Rule 23, and it's not subject to the requirement that there be judicial approval of the deal, right? And by the way, I find this positively remarkable because the judge has very little supervisory, managerial control over that settlement. This modality has become highly controversial. In a fairly famous case in the last decade, the Zyprexa case dealing with the pharmaceutical Zyprexa, this was a non-class aggregate settlement before Judge Weinstein. And at the back end, the attorneys requested enormous attorney's fees. And Judge Weinstein got very upset at this, which was interesting because Judge Weinstein is kind of very liberal in our class action mass tort arena and approves everything. And the fact that Judge Weinstein got upset at the attorney's fees was rather surprising. And he was so upset by the attorney's fees that he kind of sua sponte decided to exercise judicial control to reduce the attorney's fees. And of course, the litigants, the parties here, were saying, well, what's your authority, Judge? Okay, this is not a Rule 23 class action, and you have no authority to adjust attorney's fees. And so Judge Weinstein came back and said, yes, I do, because what we have here is a quasi-class action, a quasi-class action. And I have to tell you, I've been doing this for 30, 40 years, and I'd never seen quasi-class action in my life. I thought it was an abomination. I thought it was kind of like saying you're partially pregnant or something. It's like, what is a quasi-class action? Anyway, Judge Weinstein has now given us the concept of quasi-class action, and basically it stands for the proposition that a judge in his discretionary authority in these non-class aggregate litigations can kind of intervene to control some aspects of the litigation. So we have these two models. We have regular class actions under the MDL umbrella. We have non-class aggregate settlements also under the umbrella of MDL. By the way, when you do have these non-class aggregate settlements under the MDL umbrella, you also can have mediators brought in to assist the parties to reach some kind of resolution. All right. The third model here, the one I want to talk about, is, again, a more conventional type of ADR, and that's class-wide arbitration. Now, we got the end of the story of class-wide arbitration yesterday when we were told about these two Supreme Court decisions, the ATT and Concepcion and the American Express decisions. But the evolution of class-wide arbitration in the United States is also very, very recently. So if you know anything about arbitration, in the standard model, corporate defendants would include arbitration clauses in their contracts with parties. And then if a dispute arose, the corporation would invoke an arbitration clause. This is in a traditional one-on-one litigation. Well, what happened in one of these standard traditional one-on-one arbitration invocation of an arbitration clause was that the plaintiff's lawyer basically requested, if I have to go to arbitration, what I want is a class-wide arbitration. Well, this was, again, very astonishing. And it went before the arbitrator, and the plaintiff's lawyer said, well, we want class-wide arbitration. And the arbitrator said, oh, okay, well, we'll do a class-wide arbitration. And eventually, that went up to the United States Supreme Court in a case called Greentree Financial versus Basel. And the Supreme Court said that where you have an arbitration clause that's silent, that says nothing about class-wide arbitration, we'll leave it to the discretion of the arbitrator to make a determination as to whether or not you can have class-wide arbitration. Well, that was a pretty revolutionary proposition because it, for the first time, opened up the possibility of class-wide arbitration. The defense side of the docket, corporate America, was an absolute shock, and so because they did not want class-wide arbitration, and it was kind of their fault because their clauses didn't say anything about the possibility of class-wide arbitration. So then what corporate America did was they ran out and rewrote all their arbitration clauses, basically to say, if a dispute arises, you're going to go to arbitration, but you may not do it in a class, right? You can't have a class-wide arbitration, and that's the class action waiver. Class action waivers then became very, very controversial. California, which is a very liberal jurisdiction in the United States, both through statute and judicial decision, basically said class action waivers are illegitimate. That was the case that went up in AT&T versus Concepcion, and the Supreme Court, our conservative justices said, no, class action waivers are fine. So you would think, as a consequence of these Supreme Court decisions, that would be the end of class-wide arbitration. But again, it's not a complete picture because there are ways that corporate defendants, if they want to do class-wide arbitration, are able to craft arbitration clauses in their contracts to permit it in situations where they want it. And also, if you have voluntary consent, if both the plaintiffs and the corporate defendants do want to have class-wide arbitration, you can have that in the United States. The interesting thing about class-wide arbitration in the United States is the AAA, the American Arbitration Association, has a set of rules for the conduct of class-wide arbitration. And actually, there have been over 100 class-wide arbitrations in the United States. What's interesting about that procedure, it's a two-stage procedure. The first is that the arbitrator has to make a determination whether or not it can go forward as a class action, and the method by which they do that is exactly replicates the certification process in the class action rule. If the arbitrator makes a determination for a class action award, if it's disputed, it can go out to the federal court for review. If it's approved, then it goes back to the arbitrator, and the arbitrator will arbitrate it on a class-wide basis. So again, this is done. It's interesting. We've had class-wide arbitrations, and again, similar to non-class aggregate litigation, it has its benefits, but there are also criticisms of it. All right, and lastly, the fourth model that I want to talk about is the introduction in the United States of fund approaches to resolving complex aggregate disputes that reach large numbers of claimants. Fund approaches actually were used on the continent in some countries, and my Astrid is here. Germany actually is one of the countries that has had fund approaches. Some of you might know in the cases dealing with thalidomide in Germany, the UK, and Japan. Those were resolved not through tort litigation, but by the creation of funds to compensate victims. So in the United States, this was not a very well-known type of alternative to the adjudicative tort system. We got our first major fund after the events at the World Trade Center in 2001. And within 10 days, actually, this is the only time in my entire life that Congress has acted quickly to do anything. In 10 days of the events of 2001, Congress enacted the legislation that set up the World Trade Center Victims Compensation Fund. And Ken Feinberg was appointed the special master to administer that fund. It's an alternative payment system to the tort system. If you elected to go into the WTC fund, you gave up your right to bring a lawsuit in the tort system, and then basically a compensatory scheme was set up with a date certain for applying to the World Trade Center Fund. It was funded, by the way, through the U.S. Treasury, okay, through the United States government. They were the payer on those claims. The next major fund that we had was after the BP Gulf Oil. Again, Morris Ratner mentioned this yesterday. BP went to the White House and with Ken Feinberg, and they created the Gulf Coast Claims Facility. Again, it was a model similar to the World Trade Center Fund in that it provided an alternative mechanism for persons giving up their rights to pursue a tort or other claims in the judicial system in exchange for a faster resolution or payment of claims. Since the World Trade Center Fund and the Gulf Coast Claims Facility, we have had a large number of these funds set up. After mass events, a lot of them, unfortunately, in the United States deal with mass shootings on campuses and in movie theaters, things that we're famous for. Anyway, when these events occur, it is now very common for a fund to be set up. In almost every one of these, Ken Feinberg winds up being the administrator. He's pretty much the go-to guy for administering funds. The most recent incarnation of this was when General Motors got involved with a prospective litigation dealing with ignition switch systems. And to my surprise, GM said, we want to set up a fund, and they went to Ken Feinberg. And so immediately, basically to avoid having to go into the judicial system and face various kinds of tort liabilities, they said, we want to set up a fund, and we want to resolve these claims in this fashion. So in summary, in conclusion, what I want to say is we have a very, very fluid landscape here. And to go away with the impression that the way complex cases are decided in the United States is strictly under Rule 23 is not exactly accurate. And what I would like you to take away is that our dominant modality now are MDL proceedings, and things are pretty fluid under this MDL umbrella. With each one of these mechanisms, you were talking about this movement towards innovative ADR procedures. It is not without controversy. A lot of the things that are being done here are highly controversial. Personally, I have found the movement towards non-class aggregate settlements to be somewhat troubling because the deal is not subject to judicial review. And so all of the protections that we have built into the class action rule that are intended to protect the due process rights of absent claimants are not there when you have a non-class aggregate settlement. And I've also written somewhat extensive critical commentary about the evolution and development of fund approaches. And there my concern, again, is with claimants and the lack of informed knowledge and consent before people give up their right to go into the adjudicative tort system. And I wish that we had better mechanisms, basically, for advising potential claimants, because in a way they don't know what they're giving up, and sometimes people are asked to make pressured decisions very quickly about whether or not they're going to accept an alternative modality. So with that, I will. Okay.
Perfect. Thank you very much indeed. That sets the scene for everything else wonderfully. And I absolutely agree in relation to the question of innovation. There's some extraordinarily interesting things happening. One can see historically how things move, and they may appear to be quite small steps, but all of a sudden some very big things have shifted the landscape quite extraordinarily. I will try and remember to pick up your point about funds, because that's a relevant point in Europe. A lot of internet selling, trading, has used online dispute resolution. So Amazon, eBay, etc., Alibaba, all have these techniques that are based on perhaps arbitration or perhaps something less formal. And commercially speaking, those types of traders have always said that they could not have made such astounding commercial practice in expanding their businesses without the backdrop, the support of there being a dispute resolution system, and partly a disciplining system with feedback from customers in relation to traders. Those concepts of a mixture of dispute resolution and a mixture of regulation, if you like, have been put into new areas. I spend a lot of time talking about consumer ADR, which are rather more earth-based, if you like, systems. But the ODR system around the world has expanded quite a bit. Now, Dr. Orna Rabinowicz-Aini is going to take us even further into the ether in looking at something extremely interesting, which is absolutely the cutting edge at the moment of cloud-based trading. Or there you are. You can talk about anything after that introduction.
Well, thank you very much. It's a pleasure to be here this morning. I want to thank the organizers. It's my first opportunity to speak, and really commend them for this impeccably organized and super rich conference. I'm, for one, jotting everything down and learning a lot, so thanks a lot. I'll also start with an apology due to a family event, a family occurrence. I'm going to have to leave after this panel. There are many conversations I started here, and I would like to continue, so please, I'm on the Haifa website, and I'm happy to receive emails and continue this conversation. And as you may understand, with family, this is engaging in dispute prevention, which I'm going to talk about as well. So I was very inspired also by our discussions yesterday, and Chris had mentioned Cappelletti and access to justice, and I was reminded of this article by Mark Galanter, which I really like, Justice in Many Rooms. And there's this quote I've used recently somewhere, and I'll read it to you, where he writes, "Is the utopia of access to justice a condition in which all disputes are fully adjudicated? Surely not. We know enough about the work of American courts to suspect that such a condition would be equally monstrous in its own way." So that's sort of one strand of the discussions we've heard yesterday, right? The fear of abuse and what it means to go to court, and whether that's even a desire. And we've seen sort of the different cultural approaches to that. But then I also sort of, by the other side, right? In my other side of the brain, I'm hearing Auerbach and his message in his book, Access, where he asks whether, the book is entitled Justice Without Law. And basically he asks, can there be justice in ADR without law in the background? And I think, Chris was just talking about that. So it seems to me we're really talking about an ecosystem where we're searching for this balance between the different mechanisms to see what works. And basically what I'm sort of shining a light to an arena today, which where there is no ecosystem and almost no system, and we've talked about which avenue is preferable and what exists, and what we're going to look at today is an area in which there is a lot of activity, a lot of disputes, a lot of consumer and worker grievances and needs, and very little avenues for redress. Okay, and this arena is going to grow even further, so I think it's worth looking there and seeing what are the sources of the problem, where are the failures, and how we want to think about this innovatively. So the sharing economy, I'm going to talk about what the sharing economy is in just a few moments. But for those of you familiar with it, Airbnb, Uber, these types of endeavors, I think many of us have started using in the last few years, a bit different from traditional e-commerce if we're thinking about eBay and the sort of goods-based economy. Here, there are a lot of services, people are actually providing services, either from afar or in the face-to-face world, but it's being done through technology. More and more people either buying services or goods through this system or delivering goods and services through this system. For these types of disputes, our traditional mechanisms, courts and face-to-face ADR, are practically unavailable, non-existent. But when we look at these platforms, these huge platforms making a lot of money off these activities, we also see that not many new alternative technology-based avenues are being offered, and this is very different from the sort of first stage e-commerce companies like eBay. And so I want to kind of first flesh out in my abstract. I brought a few stories which are true to the extent they are true. I found some of them online, and some of them were recounted to me by people, and they give a sense of the types of problems that arise when people consummate these transactions. So Elance is the site that connects freelancers globally, right? So you need something done, you need an ebook written, you need a website designed, you need legal work maybe performed for you. You can order it from afar. There is a client who's ordering the job, who's basically a customer, and there's the freelancer who used to be a worker in a different type of scheme, right? But they're freelancing here. And there's Elance, and when you ask Elance what they're doing, oh, we're just a platform. We connect people with one another, right? Okay. So this freelance writer prepared an ebook for a client. She said, she performed her job well. There was a disagreement over the quality, as there typically is, over the quality of the product. Ultimately, Elance was involved, and the compromise was that the person who delivered the work received a fourth of the original amount and ended up with a negative review, which is a big problem on these types of sites, as Chris mentioned. Another story, a young woman orders a room or an apartment on Airbnb. She gets locked out. The owner is nowhere to be found, somehow manages at the end of the day to reach Airbnb. She's not charged for the room, but has to pay a higher amount for a hotel room, is never reimbursed. Kevin performs a hit for Amazon Mechanical Turk. For those of you who are familiar with it, AMT, Amazon Mechanical Turk, is basically like Elance. It connects clients and workers from afar, but they perform usually very menial, small tasks that a computer cannot do. You need a human. But they could take minutes or seconds, sometimes more. And typically people are paid anywhere from a cent to a few dollars, typically lower than what you would consider minimum wage. So Kevin performed this job for Amazon Mechanical Turk for $1 and it was rejected. Then he performs it. It was posted again for one penny. He did it. He was paid. The requester never responded to his request to be paid for the original hit. Amazon, when requested to intervene, said its policy is not to interfere in disputes between workers and requesters. And even though that's their position, they actually did contact Kevin, the worker or freelancer, to tell him that the requester complained about the quality of the work. Okay, so what is this sharing economy? What makes it different than traditional e-commerce? So obviously, this is a very rich and diverse area, and not many people agree on one definition. But typically, it's described as a new business structure that uses technology to allow for peer-to-peer collaboration over the delivery of services, goods, activities that used to be delivered either by a specific occupation, if you think of taxi drivers, or by a regulated industry, if you want to think of hotels. And it's described many times in very positive terms. Think about this great name, sharing economy, right? So as a very empowering phenomenon where individuals are transformed from being passive consumers to active suppliers, where you have a very rich and diverse market where prices are much lower than they used to be. And indeed, many consumers are empowered and have a wider choice, but those same consumers are often participants in this market, or it may be their brother or sister or some other person they know who's a worker on this economy. So the relationship is kind of complex. And what this economy makes use of is this distinction between ownership and use. The fact that I own something, people realize, doesn't mean I make use of it all the time. And I could actually use what I own to rent it out and have someone stay in my extra room, and cars are only used less than 10% of the time. And the sort of famous example are power drills. 80 million power drills in the US used for 13 minutes in their lifetime, right? So people can share power drills. Well, it turns out people don't like to go somewhere and pick up a power drill and then return it. But really this basic understanding that individuals have these goods and have time they can supply in terms of small jobs and tasks they can perform during their free time. And technology is a huge part in enabling this market. When we ask ourselves, where did this market emerge from? Well, developments in technology have made it possible. The shift from PCs to smartphones have enabled us instantaneous communication with huge markets, and we are able to consummate these transactions in matters of seconds. Reputations are up. We can review them almost instantaneously. And reputation systems are all the more important. You know, we had them in eBay as well, but they become all the more important here because unlike the risk in eBay where, you know, maybe I ordered some product and I didn't receive it, or maybe I sent a product and didn't get paid, types of problems that have been that we've learned how to deal with over the years. With services, the risks are greater. I'm letting a stranger into the privacy of my own home. I get into a car with a driver, I don't know, may not work for some company, okay? So the risks here are much bigger. And also the types of solutions you can find for the problems are different. And even these companies, I think, are finding out that the whole reputation market is kind of more complex when you think about people who know where you live, right, have been to your home, and you start putting up these reputation systems. So this is a very complex environment. Also, there's not a lot of sharing going on, okay? This is very romantic to think of us as a sharing economy, but there have been other names, and many have objected to the use of the sharing economy, on-demand economy, renting economy, 1099 economy. While the sources of this move towards the sharing economy have been quite laudable, you know, this feeling of a search for sustainability and feeling that we've been over-consuming and we can consume less and make use of what's out there by renting out things. And also in the aftermath of the 2007 economic downturn, the fact that people can spend less because they have less to spend and also need to make ends meet and therefore need to find these odd jobs and tasks that they can perform to supplement their income. These have all been laudable sources for the rise of the sharing economy. But nevertheless, the sharing economy, major sites at least, I'm not talking about the not-for-profits, there are a few that are true sharing collaboratives, but the major sites have been critiqued basically for allowing big business to make even more money by basically getting rid of a lot of the costs that regulation places on business because they've dropped all costs relating to labor and employment. Everyone, they're not doing anything. They're just connecting people, okay? So they're not hiring. If you look at these companies, they actually have a very small number of employees who are well compensated. And then basically all of the work is being delivered by the freelancers who are described as independent workers. It's big. Over 9,500 companies, 130 countries, in funding over $8.5 billion. This is where I took the information from. PwC estimates in 2014 that the sharing economy brought in global revenue over $15 billion. And the estimate for 10 years from now is $335 billion. Okay, so there is a lot of transacting going on. And we know that where there are transactions, there are disputes. Disputes and problems are an inherent part of just communicating, okay? Even if everyone is well-intentioned, we are going to have problems and we're going to have disagreements. And, you know, how many disputes are out there is a big question. But typically, and I've seen several people who are involved in these markets talk about it. Some talk about 1 to 3% of transactions. Others talk about 3 to 5. I guess it's somewhere around the 3, which, when you think of these numbers, is a lot of disputes. I've heard a figure of an expectation of 1 billion e-commerce disputes a year by 2017. I know that eBay handles 60 million disputes a year through its very elaborated automated system. Think of a court handling 60 million disputes. Granted, they're very simple, they're repetitive. We can think of, you know, they're not very emotional, although they may be. But eBay has actually instituted a very elaborate system that handles 80% of these 60 million disputes without a single human involved, okay, all through algorithms. And why did eBay need to do this? Because for many of these disputes, our traditional mechanisms don't work. They cost too much. Sometimes, as you've seen, some of these transactions are cross-border, cross-cultural, cross-language, very difficult, very expensive to convene in one place, not always possible. Even when we're in the same location, these transactions are so quick, and having a tarnished reputation may impact our ability to transact to a very broad extent. And so we need fast mechanisms that can address the problems quickly and don't take months and years to get into action. And this realization has, as of the mid-90s, really given rise to this new field or subfield of dispute resolution called online dispute resolution, where the understanding was that technology is not only disruptive in the sense that it is creating a lot of conflict out there, and it is creating a lot of the conflict because the pace of technology, the scope, the number of people we're reaching, the fact that much of the communication is very thin, it's missing facial tones, it's missing, a lot of it is in writing. So there's really a high probability of conflict erupting, probably more so than in face-to-face interactions. And we're missing a lot of the trust mechanisms that we have in our physical environment. So technology is not only giving rise to these disputes, but it can also present us with new tools for imagining how to address these problems. And eBay, as I mentioned, has been really a leader since 2000, has evolved with creating its own internal system. And I think that had a lot to do with what eBay was and who Pierre Omidyar was, who started eBay, and his sort of sense of what the online environment was all about. But the eBay model has really served as an example, and I think has pointed to the direction that now when we think of consumer redress, and I want to broaden the discussion to workers as well, but when we think of consumer redress, we're understanding that in our day and age, we have to think more and more about online redress. And the EU has certainly taken note of that and has taken action. And even on the global level, we see now that the UN, for several years now, in its pre-digital pace, is trying to generate an international vehicle for addressing cross-border consumer disputes. We also see some courts trying to incorporate these mechanisms for the local avenue. So what's happening in the sharing economy? Maybe we would, I mean, I would have thought this would be booming with ODR, right? Okay, it's the perfect environment for ODR. Well, actually, when you look at these sites, they're not booming with ODR. Some parties have more options in terms of redress avenues. Consumers fare better than the worker side of the equation. And there is also another axis of distinction between who are the parties to the dispute. Are we talking about the user-to-user disputes or the user-to-platform disputes? And bear in mind that the business here has really sort of shaved off a lot of what would have been in the past platform to user disputes, these are now user to user disputes because the business is defined in a very narrow term, okay? And it's being challenged. And actually Uber is a very good example because some Uber drivers have had success in courts in the recent year in challenging Uber's classification of drivers as freelancers. So that's an interesting, when we talk about this ecosystem and the role law and even class action with respect to Uber is playing in the background, that's a very important development. And there's no information out there about, you know, how they're handling disputes, how many disputes. When we talk about private justice, this is sort of a major issue. In Europe, I think things are going to change, but we need to bear in mind that the European regulation applies to member state companies and these sharing economy endeavors, these huge sites are based in the US. Okay, so it'll be interesting to see if this affects how they think about these issues. And I think there is good reason for optimism that some of these trends will change, but there's going to have to be, I think, a strong regulatory drive for that. So let's look at some of these sites and what's out there. So Airbnb, how many have reserved rooms through Airbnb? Okay, so fair share. So 60 million guests, 190 countries, 2 million listings. They offer a limited sort of institutionalized dispute resolution process, nothing like the sort of elaborate attempt eBay had of classifying the various disputes, mostly geared towards the consumers, the guests. And they invest a lot. We see this in all the sharing economy companies. They try to invest a lot in the prevention I mentioned earlier, right? Creating the reputation market, which they were kind of hoping would solve all their problems. They wouldn't need to do anything, just put up a reputation market and things would take care of themselves. As I mentioned, it's very complicated, especially in the services area, so it hasn't proven to be such a success, and there are a lot of manipulations on reputation markets. And they create incentives for hosts, a super host status. If you want to, you know, maintain your status, you need to make sure there aren't any problems, so hosts go out of their way to make sure. You have background checks. They allow users to connect through their Facebook profiles, so people are less of strangers to one another. You discover that somehow someone knows someone you know, right? And it gives some connection. There are security deposits, insurance that's offered, this recent development. You see a lot of sort of norm generation, a lot of information and sort of tutoring for new hosts and guests, and a lot of do's and don'ts and rules. And basically these are prevention efforts, right? And very interesting, I read this interview with one of the guys who started Airbnb, a lot of use of big data in studying patterns. And what they can do with big data, I think, is staggering. I mean, they obviously don't disclose a lot of what they do. For one thing he did mention was that they actually, you know, when you say, for example, we want to go to Paris. So potentially there could be many listings that come up with respect to the area we want to stay in Paris. So they actually, in deciding which listings to show us, they claim they can actually try and pick those listings in which there is a lower chance of dispute erupting or problems arising. So this is pretty amazing. I mean, I don't know how their algorithm works. That's part of the problem, right? We don't know how these algorithms work. But they certainly use big data in ways that we are not quite familiar with. But what we see with the prevention mechanisms is that these have evolved over time, and usually after there was some big scandal involving, you know, some kind of problem, so they institute some kind of mechanism. Obviously, platform disputes are subject to binding arbitration with class waiver. Elance, I mentioned earlier. Over 10 million, it's now called Upwork, I think. They now have over 10 million freelancers, $1 billion work annually. They actually do have kind of elaborate dispute resolution system for workers vis-a-vis clients. They distinguish between a per hour work and a fixed price job that was ordered. And interestingly, they'll intervene in a per hour dispute if the worker agreed to use a very intrusive software that basically provides screenshots of their computer on which they perform the work. It's very controversial. A lot of talk about this in the blogosphere, a lot of resentment towards subjecting the workers who are disempowered as it is to this kind of intrusive surveillance. And basically the claim is, again, if we're talking about how these platforms describe where their responsibility starts and ends, basically they're saying if you want workers to be subjected to this kind of surveillance, then they're workers, they're not freelancers, right? Then they have a virtual desk in your workplace and they're not freelancers. So through the dispute resolution systems that they institute, we actually learn a lot about these companies more generally and about this environment. They do a lot of prevention work as well. So I didn't describe the process, but there is a process where there is a two-way negotiation, and then ELANS will intervene, and then they can escalate to arbitration. But the parties are encouraged to define the work clearly, to communicate through the site, so there's documentation. And typically, you know, in a per-hour job, they have arguments over whether about the number of hours worked, and for the fixed-price job, there will be arguments over the quality of the work and whether milestones have been met, etc. But what they, ELANS, interestingly, takes the user ranking and supplements it with its own sort of additional layer of rating that's taken from the data ELANS collects. So it has this more sophisticated pattern it uses, and it serves the consumer end, obviously, not the worker end. Again, you see this dichotomy between the customers and the consumers and the workers. Interestingly, sort of the online environment has given more power to consumers than in the traditional setting, and workers, who I think in the face-to-face setting were doing better in ADR, are actually doing worse because of the sort of political and social setting in which they are operating in a very tough market and in the global setting. Again, the class action waiver with the disputes with ELANS structured a bit differently. TaskRabbit, to those of you who know, started in Boston. Local, this is face-to-face services. You want someone to pick up your dry cleaning, you want someone to drop off a coffee, you want someone to clean one room in the house that you're afraid to go into. All of these kinds of tasks you can think of. TaskRabbit is there for you, the eBay of jobs. You search through the sites, no dispute resolution really, some prevention, again, the norm generation, do's and don'ts, pre-screening of the people who are working, a lot of focus towards the customers and the concerns customers have. Again, when you search the blogosphere with respect to all of these endeavors, you find a lot of complaints, very unhappy people about how disputes are addressed, about the who's responsible for problems that arise. And platform disputes, a variation, first attempt to negotiate and then binding arbitration, class waiver. Amazon Mechanical Turk may be almost the worst. You might have heard the Turkers, the workers, actually wrote a letter to Jeff Bezos. They wrote a letter. There was a lot of discussion of the ways in which these workers are abused. Actually, the academia is taking part in this. A huge portion of academic research is performed through AMT. I have to say, it's been a dilemma for me too when I've been working on quantitative research. If you want to do something like that, the thing today is to just go on AMT and you get, you know, thousands of people. You know, can fill out these questionnaires, and it's very low amounts of money. And actually, when we were contemplating this, we said, okay, we would offer a higher pay, but then people said, then you wouldn't get the sample. It would be tilted because typically people pay low amounts. So it's everywhere. So what does AMT say? Our policy is not to interfere in disputes between workers and requesters, and as stated on our site, all approvals and rejections are at the sole discretion of the requester. If you feel a requester has unfairly rejected a hit, I would suggest you contact them to see if you can work something out, okay? Now, when users were when Turkers were asked about what they would do to improve AMT, I found it super interesting. I just took a few examples. Many of them referred to dispute resolution mechanisms. Okay, so I would create a conflict resolution center and have requesters who do not know what they are doing at least spend some time as a worker to get a feel of the system. I've heard horror stories about how workers' accounts have been closed and funds tied up, and there isn't a phone number to call or an actual email address to use that is reliable. A few hard blocks from crappy requesters can ruin a Turker, yet a Turker is powerless to find out what the problem is, make it right, etc. I would allow the users more control over disputes. Amazon is really horrible with users that get blocked by requesters that don't really have a reason. They have no dispute or resolution thing set up for mTurk, and not allow requesters that continually make new names to scam workers get involved in some of the major disputes with requesters. It's really strong, I think. Again, an arbitration clause, a bit different. Uber, search the site, there's really nothing. Interestingly, I found a wiki site that explains to customers how to best how to best question a fare you received on Uber, but really nothing about the drivers. Despite the class waiver and arbitration clause, there's actually interesting litigation against Uber going on with California courts, actually deciding that the arbitration clause in its initial wording does not apply. And in the meantime, the class action seems to be going forward. So in conclusion, what did I want to sort of have this discussion about? There's a huge market out there for consumers and employers. Traditional mechanisms don't work well. They will work in extreme cases, and the Uber case is a good example of how they can also complement some of the other mechanisms that the more creative mechanisms we might want to devise. ODR provides, in this setting, a very limited redress. The way ODR has been used has been very limited. And I think it's helpful to look at the ODR that's out there through the prism of these two axes. To look at the type of dispute. Are we talking about consumers or workers? And there we find a real hierarchy where consumers are treated much better because it's in the interest of the platform to treat them better. Again, not perfect. I don't know whether this is an equitable dispute resolution mechanism. There's no information out there. There are no incentives to ensure that they are doing all they can do to ensure that this is resolved fairly. If you look at the party to the dispute, again, this shaving off of responsibility by the platform and blocking through mandatory arbitration while giving some redress in the case of user to user, depending on the platform. We saw AMT giving nothing while ELANS provides some kind of mechanism. I am, however, optimistic that this will change. I think we're at a point where both the scale of what's going on in the sharing economy and other developments, also regulatory developments and developments in the courts, will drive us to more change. I think ODR is gaining more legitimacy, among other things due to the EU regulation, but also experiments with ADR in various court systems. I see more, I mean, it would be interesting to hear what Linda and Rhonda think also. I think there is mounting pressure on the issue of mandatory arbitration. There is, to my understanding, a federal agency that's looking, at least in the financial sector, that's looking into banning these types of clauses. So it'll be interesting to see what happens there. And we see, I think it's in many different areas, not only in the sharing economy, we see a lot of pressure by users that the platforms intervene and take responsibility. I mean, even if you think of the recent Facebook lawsuit filed with respect to the stabbings, and calling Facebook to take more responsibility for the content on the site. Okay, so Facebook is not sharing economy platform, but you can see how this position of we're just a platform, we're letting the users talk and fight and upload whatever they want, it's kind of, you know, it's not working that well anymore. There's an expectation that these platforms take more responsibility, and taking more responsibility means also creating an infrastructure for addressing disputes, and creating that infrastructure, I think, ultimately in an equitable and not only an efficient manner. I mean, when we look at ODR, one of the striking things to me, if we think of, traditionally in procedure, we always thought there was this inherent trade-off between efficiency and fairness. And obviously, the tension is still there. But ODR actually has the potential of expanding both sides. And I think the problem has been that we've looked at ODR as an efficiency enhancer, mostly, okay, because we don't have to convene, we can do it 24/7 from afar, and everything is very convenient with the documents, etc. But it actually has a lot of potential on the fairness side of the equation as well, if we think of the possibility of structuring discretion through software, through algorithms, if you think of consistency in decision making, if you think of the added advantages of documented data and the ability to use big data and learning to find the various patterns, where in the world could we learn about the impact of procedural choices on outcomes for distinct groups of individuals? We never had that kind of data. For the first time, we have that data, and it's in hundreds of thousands or millions and tens of millions, which to me is staggering. So I think there's a lot of potential. We need law and legal structures to give us a better sort of ecosystem in which these mechanisms could function not only in an efficient manner and to the extent that the platform cares, but also in a more equitable and broad manner. Thank you.
Which is full screen. Here we go. I got it. Thank you. Now, just a few words about more Earth-based ADR in Europe. Your final comment reminded me that the Directorate General on Communications, called DG Connect, of the European Commission, knows that communications technology, etc., as well as dispute resolution, moves so fast that by the time the EU has worked out how to regulate it or how to provide any system, it's years behind, years too late. And the message I'm getting from you is I thought ODR was the new frontier and it's already out of date. Therefore, the DG Connect has for some years organized what they call a community of practice, which is effectively encouraging voluntary regulation and voluntary dispute resolution and sharing information. So if you look at the DG Connect's website, they've got quite a lot of self-regulatory or other ideas in order to deal with the two problems of behavior and redress. So what we're really talking about is different ways of doing that. Now, in relation to most consumer disputes, certainly in Europe or indeed anywhere, they are very small amounts of money. Most of them are perfectly straightforward issues, like the item didn't arrive or it was damaged or whatever, and that really is very small amounts of money. Most countries, even with responding 20 years ago with small claims mechanisms in courts, simply do not respond to that. It's too difficult, it's in fact too expensive, it's not cost proportionate, etc. So there are vast numbers of consumer disputes that exist that fly under the radar of courts or lawyers. And that's partly, certainly in the UK, an element of lawyers overpricing themselves out of that, but actually it's it's impossible because most of these things are so small. Now, the EU has spent some time in thinking about small claims procedures on a cross-border basis, and that exists, and there are various other mechanisms called European Order for Payment, or we heard yesterday about collective redress mechanisms, and one saw that actually the EU found it rather difficult to move forward on that issue, but the EU has definitely moved forward and taken big leadership initiatives in relation to setting up a pan-European structure for consumer ADR. It was discovered that there are quite a lot of consumer ADR bodies across countries. They're all different to some extent. You find models. So you might find consumer arbitration tribunals, courts, whatever you call them, for example, in Spain and Portugal. You would find consumer ADR boards, which are technically non-binding arbitration in all the Nordic countries. And you would find various different types in other places. So this initiative was put together by the Commission some time ago and resulted in a directive that was passed in almost record time through the European Parliament, which shows how much political support there is for it, unlike the collective redress issue. Support from the government, support from Parliament, support from everyone. And it was a directive 2008 that was to have been implemented by July this year. In fact, many of the member states are late doing that because it's raised all sorts of difficult questions about modernisation of the existing ADR landscapes that exist. Sorry, it wasn't 2008, that was the mediation directive. This is 2013 directive. It's coupled with a regulation on online dispute resolution. So the broad mechanism is that you could have a number of traders who belong to a consumer ADR body. And it could be an arbitration court, if you like, or it could be some sort of dispute resolution board, or it could be in England or various other countries, might be called an ombudsman. The word ombudsman means different things in different contexts, which gets very confusing. The ADR bodies, if they are to exist in the new world, must satisfy various quality requirements, which are constitutional requirements in relation to independence, expertise, etc. And they have to be approved and are regulated by national regulatory bodies, which are called in Eurospeak competent authorities. The concept of competent authorities is well understood. So, for example, medicines agencies or financial agencies or whatever within the European system are known as competent authorities. So this is just adopting that regulatory architecture. For cross-border complaints within member states, you might have a consumer in Italy and a trader in Finland. The dispute can be bounced off an ODR platform, which is notionally above Brussels and held by the European Commission. They've had a few teething problems in that, and they've done some piloting, and it still hasn't gone live. It's supposed to go live in January. And that's supposed to link into the national architectures of ADR bodies, but actually there's a bit of a dispute about that between the member states about whether it will or not. And at the moment, none of this is mandatory. This is just a first stage. In typical building of EU legislation, you do it bit by bit over several years. So you can read a number of academic articles that complain about the fact that it doesn't do this or that, and it's not mandatory, and the decision's not mandatory, etc., etc. That is deliberate. You only change things a bit at a time, and this stage is merely putting in place the basic architecture, but it is quite revolutionary architecture, fairly simple. So at the moment, you could ask a trader if they will, if you have a dispute. The traders now, by law, under the ADR directive, when it's implemented in a particular country, have to inform the consumer whether they belong to an ADR body or not. So they don't have to, but if they do want to, they have to have an information requirement about saying who it is, and then the dispute can go there if it's agreed. Now, in some countries, and for some sectors, it is actually mandatory for traders to belong to an ADR system. For example, in the UK, it's been mandatory for many years for all banks to be subject to the jurisdiction of the Financial Ombudsman Service, the FOS. And in that particular arrangement, there is then a decision that comes out of the FOS. The consumer is not bound by it, because we preserve Article 6 of the European Convention on Human Rights, that the trader could always go to court if they like, or just reject this. So the primacy of courts, at least for the moment, is guaranteed. But if the consumer accepts the proposal, then it is by law binding on the bank. Quite a number of countries, various sectors in Germany, especially insurance and transport, or various, almost every sector in the Nordic countries, it's binding by convention with exceptionally high adherence rates. So it's technically not mandatory, but in practice it is fairly wide. This is merely to show that one can actually work out that, and this is almost a sort of small big data point, that there is research that's been around for a long time telling us where most of the consumer disputes are. So therefore, this is in the UK recently, and the ADR system will be targeting, you can see on the right-hand side, some have got yes, like there is an ombudsman and a separate ADR scheme in telecommunications, and all the communications firms belong to those. And there are one or two others in this list. There's an ombudsman for legal services, so all lawyers are subject, in relation to complaints, it's subject to the legal ombudsman. There's a pensions ombudsman, various others. But one will be targeting those where there's no current provision, talking to the trade associations to say you need to join this, or we will mandatorily make you belong. I didn't know what any of these things were, certainly 5 years ago. So my team and I spent, this is another blatant plug, my team and I spent 2 years running around 10 countries, talking to as many ADR bodies or ombudsmen as we could find, and we've done a few more countries since then. And the answers are all in here. This is an exceptionally boring book, but it gives you an enormous amount of information about how all the systems actually work. And we will be updating it because they're all changing and putting more detail in about how things move. But it basically is the only source of information because we're allowed to have time to go around and say what actually exists, what is there. The different systems at the moment are evolving. So, as I said, there are groups of countries. This is a sort of Nordic model. So you've got a number of sectors, say usually all the regulated sectors like financial services, insurance, communications, energy, utilities, water, etc., that would have their own vertical boards that are all paid for but are independently run and operated, but paid for by the sector. And they've obviously got sectoral expertise, so they're very efficient. And most people would go straight to those. If you don't want to, you've got a national board in Finland, Denmark, Sweden, Norway, to who you could go, and they could handle anything. And they do, and they've been doing that happily for 40 years. No one goes to court in the Nordic countries. It's almost unknown for consumers to bother going to court. Similarly, there is a system next to this in Nordic countries in relation to personal injuries. So that deals with not just road traffic or workers, but certainly patient injuries and smaller version, which is frequently integrated into it, for drug or device injuries. They're used all the time. No one goes to court. They hardly exist. There are few consumer lawyers. And the consumer associations, or the equivalent, are sort of tied in to this system and involved in the government's issues. The Netherlands has got an exceptionally interesting model that it's developed, again, over 40 years, but it's not really replicable anywhere else. Some academic colleagues of ours sold it to Bulgaria a few years ago, where it has failed because of the local conditions, should we say. But in the Netherlands, it works incredibly well. There is a separate channel for financial services within which you've got several tiers, the first of which is an ombudsman, and then there's dispute resolution boards and a couple of tiers over that. But the idea here is that you've got at the bottom, again, trade associations, and at the moment there are 54 different trade associations. That is pretty wide coverage. That agree with the Consumer Association every 3 to 5 years what their terms and conditions are going to be. So the terms and conditions deal with every major systemic problem that has been identified in that sector by either side. And the debates take place under the aegis of the State Council, so it's given a formal approach. And they always agree. They never leave anything out. They will agree a provision on something. And therefore, the terms and conditions in that sector are always higher level of protection than the EU-based law on consumer protection. One of the terms is that the trade, if for any disputes that might arise in that sector for members of the trade association, the disputes can be referred straight to this Geschillenkommissie system. And the trade association will pay for it. It's basically for the systems across different countries vary as to who pays what. But usually there's a very small fee payable by a consumer, or the main trend is it's free to consumers. It's paid for by the businesses because the businesses say this is good for us, it's good for our reputation. Not everyone gets that yet, but that's the trend. So therefore you can go to this system, and although the decision that comes out looks like arbitration with a panel of 3 and a consumer representative and a business representative and maybe a judge in moonlighting in the middle as chairman, it's not binding. But if the trader doesn't pay, the clever bit is that the trade association guarantees to pay. And obviously the trade association will then go and beat up the trader and throw him out. There are more models like this. So as I say, in England, much more so than in Germany, we've got a lot of sectors and quite a few statutory ombudsmen. So that's the basic idea. There are techniques. We're out of time. I just want to take one minute. The Financial Ombudsman Service is the biggest ADR system there is because there's an explosion of problems with the banks mis-selling payment protection insurance policies 10 years or so ago, and this is still being worked out, and it's ended up with the banks paying at least 26 billion repaid in small sums, a lot of small sums, to a lot of people. You can see the statistics. So you see them very, very much operating on a pyramid basis. So last year, the Financial Ombudsman got nearly 2 million contacts from consumers. And that could be people saying, this has happened, what do you think? So it's advice. It's a huge amount of advice, but it's also a huge amount of big data. That boiled down to about 400,000 actual disputes that were then solved, mostly through mediation, conciliation, triage. And the Ombudsman only had to make a decision in 43,000 cases. The majority, and so the numbers are going down, hopefully, because of payment protection insurance going away. Now, you contrast that level with, these are small claims hearings in the courts, actually hearings, and they're only 10 years ago, 15 years ago, they were at 60,000, and they've halved to 30,000. That's tiny. That's every type of claim in the small claims court that goes to a hearing. So the Financial Ombudsman is already massively bigger than the court system. And then you take into account the rise going up of telecom ombudsman, energy ombudsman, et cetera, et cetera, et cetera. And the explosion, there's a huge shift away from courts. Now, the Financial Ombudsman effectively operates a mass redress system, very much like a sort of class action or group litigation order, because someone just says, we've got a lot of cases like this, what are the general points? So if there's a general point of law, it could be referred to a court, although the mechanism needs to be improved. And then the Ombudsman will just apply that on an individual basis themselves very efficiently. The payment for the Ombudsman, and this varies in different systems, is a levy that's made by the financial regulator from the banks on an annual basis, and they pay a case fee. They get some free, but otherwise you get an incentive to settle things at an earlier stage, in-house or at an earlier point. So there's huge change. Ombudsmen are now able to act as regulators by aggregating the data, publishing it, feeding it back, telling the banks and the regulator, there's a new trend, you need to sort this before it blows up. So they're now doing that. But they're also able to turn around to traders, such as payday lenders recently, and say, your terms and conditions are not good enough, fix it. If you don't fix it, we'll refer you to the regulator and they will come looking and maybe prosecute you, which they do. But otherwise, just fix it. So therefore, the ADR system is extended out to being consumer advice, to being a lot of information about data, and the national governments are now beginning to think about extending that horizontally across all sectors, because I'm just talking about one here. So what architecture do you need to do that? And then it's recycling the information. So all these are in a different model. I won't go further just for the moment, other than to say that if you start looking then at a different architecture in personal injury compensation schemes, funds, there's a lot of them out there. And certainly we're involved in discussions in the UK with governments and doctors about doing that sort of thing. I'll leave that one till later. Let's break, do we? All questions?